Thank you very much for staying with us and joining us for this afternoon session. This session will be about the POPIA Code of Conduct for Research. I must say that I think this has been the most ambitious project that NSEF has actually embarked on. It has certainly challenged us in many ways, but we are extremely grateful to very knowledgeable and expert people on both our panels, being the drafting committee as well as the steering committee, and our advisors along the line. And we are also extremely grateful to all our stakeholders out there that have commented and has given their input towards this process. This process is still not done. We are working here at quite a speed to try and finalize and submit our code of conduct to the information regulator, but we are back on track now, and we hope to show progress very soon to everybody involved. I have two distinguished speakers joining us this afternoon. Eleni Flack Davison, she's an admitted attorney of the High Court of the Republic of South Africa, legal advisor, research compliance manager, head of the Office of the Research Integrity and the Research Data Protection Officer at the University of Witwatersrand. She's also a member of our drafting committee of the ASAP POPIA activities. Then I have Professor Michelle Ramsey. She's the director of the Sydney Brenner Institute for Molecular Biosciences, DSD NRF Research Chair for Genomics and Bioinformatics of African Populations, and Professor of Human Genetics at WITS. Professor Ramsey is also the chairperson of the NSEF POPIA Steering Committee. These were one of the projects that we thought that we should embark on. We are standing for open science within NSEF, and we haven't really paid enough attention to open data. This code of conduct is extremely important when we start sharing data across borders, not only continentally, but also internationally. And it was crucial and detrimental to the research community at large to have something like this in place so that everybody understands from which page we depart from when we start sharing information. I'm not sure, Eleni, Michelle, are you going to start just with perhaps a general introduction to this process? And then we'll hand over to Eleni. Or Eleni, are you the first one? Thank you, Eleni. I'm going to cross over to you. Please have the floor and share your slides. Thank you so much.
Great, thanks very much. If I can just get my slides up. Great. If you can just confirm that you are able to see my slides.
Perfect. Thank you, Eleni.
Perfect. Thanks very much. I'm not sure if Prof. Michelle Ramsey would like to say something before I start or afterwards.
Thank you very much. And just to say hello to everybody and to thank you for doing this presentation. And Susanna, I think you really did set the scene in terms of our objectives here. Ensuring that we can be responsible in terms of research and research data sharing while protecting our participants. And Eleni, I'm happy to join you afterwards for the Q&A, but thank you for preparing this presentation.
Perfect. Thanks very much, Prof. Ramsey. Good afternoon. My name is Eleni Flack Davison, and I'll be speaking on the POPIA as well as the NSEF Working Draft Code of Conduct for Research. And I just need to emphasize that it's a working draft code of conduct, because a lot of people have mistaken that it's a code of conduct, it's set, it's ready, it's what we can use. But unfortunately, it is a working draft, or fortunately, should I say, it's a working draft. And of course, there's various inputs that we require and that consultations that have been done and need to be done, and the formatting and everything needs to be correct so that the code of conduct can be in a place where we can send it off and submit it to the information regulator, and we get a good approval at the end of the day. So having said that, of course, we need to, the code of conduct, of course, starts with the POPIA Act. everything that's in the code, it goes straight back to the POPIA Act. So, of course, the right to privacy, personal information. The POPIA regulates the processing of personal information in South Africa. Personal information, though, is a sub-right of the right to privacy, and it's found in Section 14 of the Constitution, of course. And the clause is that everyone has the right to privacy, which includes the right not to have the person or home searched, their property searched, possession seized, or the privacy of their communication infringed. But of course, it's a sub-right. It's not an absolute right. And this right may be subject to justifiable limitations. And as we saw through the pandemic, of course, there are certain data, personal information that needs to be made public so that for the public good at the end of the day. But on the broad application of the POPI, it applies to the processing of personal information by public and private entities domiciled within South Africa or where information processing takes place within South Africa. The processing can, whether it's automatic or not, it's still part of personal information. The POPI does not apply to the processing of personal information that has been de-identified. Such information must be in a state that it can no longer be re-identified, so it can't link back to an individual or a company either. And information processed purely for household use. So within a household, that also is not applied. A POPI does not apply. So everyone asks, what is personal information? And it's a record of any kind containing information that can, though reasonably foreseeable method can be used to identify an individual. And when I speak of an individual, it can also be a company at the end of the day as well. It's information relating to an identifiable, living, natural person, and where it is applicable, an identifiable existing juristic person being a company, including but not limited to information relating to things like a name, identity number, race, gender, pregnancy, marital status, mental health status, physical status, age. All these things fall under personal information. Let's take it a step further. Email addresses, contact numbers, locations, geolocation, physical addresses, educational, medical, financial, criminal, employment history, all of these, personal opinion, views, preferences, photographs, video, footage, voice recordings, biometrics. All these things are vital and are at the core of what personal information are. Of course, what is de-identified information? So personal information is one thing, but then in order to use that information, you need to de-identify it. And it's information which cannot be linked through any foreseeable method to an individual. De-identified information in relation to a personal information of a data subject means to delete any information that identifies the data subject, can be used or manipulated by a reasonably foreseeable method to identify the data subject, or can be linked by a reasonably foreseeable method to other information that identifies the data subject. And de-identified has a corresponding meaning. And of course, within the realm of POPIA and that, we do have role players. Who are the role players? To start with, as I highlighted previously, a person is a natural or juristic person, a data subject, research participants. These are people whose personal information relates to and partakes in research that is being conducted by our researchers. And then, of course, who is the responsible party? A public body or private body or any other person which, alone or in conjunction with others, determines the purpose and means for processing personal information and is responsible for the lawful processing of such information. For example, a university for everyday compliance, a researcher, when they're out in the field, their research that's being conducted, they are the responsible person for that research that's being conducted. Another role player is an operator. It's a person who processes personal information for a responsible party in terms of a contract or mandate without coming under the authority of that party. So it could be a community liaison, a scribe, a transcriber. An information officer is an official in the employ of the responsible party who is responsible for the recipient of requests for information. So in a university context, a responsible party would be a university, and an official or the information officer would be, for example, the vice chancellor of that university. And of course, he delegates that responsibility to a deputy information officer, or who could be the equivalent of the registrar of the university. Now, in order to have our research carried out in a responsible manner, our data subjects have rights, and those rights have to be respected. And the data subjects need to be notified by the responsible party of the processing of their personal information, and for what reason. And they need to know what personal information is being held, and to request access, correction, destruction, or deletion of such personal information. And of course, to object, they have the right to object on reasonable grounds to the processing of their personal information being included for things like direct marketing purposes. They can submit a complaint to the information regulator and to institute civil proceedings if aggrieved. So it's not the POPIA and the Code of Conduct will provide processes, complaint processes, and that will be discussed further in a few minutes. Within the POPIA Act, you've got the 8 conditions for lawful processing. And these steps are vital to be able to carry out the best possible way to be compliant with the POPIA Act, and in turn the Code of Conduct. And the steps begin with accountability, because at the end of the day, that is the main thing that carries our researchers and our research. And the responsible party must ensure that all the conditions laid out in the POPIA Act are complied with at the time of determination of the purpose of processing and during processing itself. So they need to know exactly why are they wanting to do research with that specific research proposal, and they need to know what they need to do during the processing or during that research they're carrying out. The second condition is processing limitations. So there must be a lawful basis to process personal information. Personal information may only be processed if, given the purpose for which it is processed, it is adequate, relevant, and not excessive. Consent, justification, and objection. Personal information can only be processed if it is necessary for the performance of a contract obliged by law, for a legitimate interest, or for the performance of a public law duty. Collection from the data subject, except where the personal information is already contained in a public record, or where it would maintain the legitimate interest of the data subject, the responsible party of the third party, or where it is for research purposes or reasonably impractical. Purpose specification is the third condition, and this is where the information must be collected for a specific purpose. It needs to be specific, explicitly defined, and lawful, and not used for any other purpose besides that specific purpose. So if a research project is being carried out, the researcher cannot deviate from that research. Records containing personal information must not be retained longer than necessary to fulfill the original purpose, unless it is required by law. Retention of the record is required by an agreement with a third party. The consent of the data subject is given. It is required for research purposes and safeguards that are in place. Records containing personal information can be destroyed, deleted, or de-identified. The fourth condition is further processing. So processing is one thing, and then further processing. So you have a research project and you want to build onto that, and it's the next step. And that is, further processing is to be compatible with the original purpose, for example, research. And in determining this, the responsible party must look at the relationship between the new purpose and the original purpose, the nature of the information required, the consequences, the manner of collection, contractual rights and obligations. It is valid if one is further processing for research purposes and there are safeguards in place to ensure that the information will not be used for any other purposes and not published in and identifiable form. The consent of the data subject needs to be given for the further processing. The information can also be already in the public domain. So, for example, in court cases, all records are in the public domain. Another reason is for reasons of public interest, example, the pandemic that we've all experienced. The fifth condition is information quality. It is the responsible party that needs to ensure the quality of the information that is kept and stored. Quality refers to information that is complete, accurate, and not misleading, and it needs to be updated. In ensuring information quality, the responsible party must comply with the original purpose of the collection of information. Annual audits to check the information quality is required. Openness and transparency is the sixth condition of processing, and it is to maintain documentation for record keeping purposes of all personal information processing operations. Notification to data subject when collecting personal information. The data subject must be made aware of where his or her data was collected from. The contact details of the responsible party need to be provided, the purpose for which the information was collected, where applicable, that the responsible party intends on transferring the information to a third country, and the level of personal information protection offered. The responsible party is exempt from notification to the data subject if and only if the data subject has already given consent for non-compliance with the notification, or compliance is not reasonably practicable. If the information is de-identified or used for statistical, historical, or research purposes, then notification is also exempt. Personal information is collected, and the security safeguards that are put in place are vital for the legitimacy and the accuracy of the personal information. And that is the seventh condition, which is the security safeguards. And security measures need to ensure that the integrity and the confidentiality of the personal information and its processing, including verifying the operator and persons acting under the authority of their processes. The security of safekeeping, for example, need to be put in place. For example, password protection needs to be enacted. Encryption, using a system called RedCap. All these are systems of keeping the personal information safe. Another example of how not to keep data collected safe is keeping data that is on a hard drive in an unsecured place, in a vehicle that can be stolen, for example. Notification of security compromises need to be reported to the information regulator as well as the data subject. They need to know that this personal information has been stolen, lost, whatever the case may be. The eighth condition, of course, is the data subject participation. And this is where the data subject has the right to request the details of the personal information that a responsible party holds about them, and in certain circumstances request access to such information. This can also be done if the information is not provided, then they can seek different remedies through the Access to Personal Information Act, the POPIA. Correction of personal information can also be made, and the manner in which they can access such information can also be used. Authorization for processing special personal information. Special personal information is information relating to things like religious or philosophical beliefs, race or ethnical origin, trade union memberships, political persuasion, health or sex life, biometric information, criminal behavior of the data subject. The same conditions and authorizations exist under POPIA for personal information relating to children. And in terms of children, the authorization for specific consent for their personal information to be collected, consent needs to be sought, especially parental informed consent is required. And this also is enforced by the National Health Act, or the competent person in the case of information relating to a child as well. And the National Health Act needs to be read in relation to the Children's Act. The children are seen as a part of a vulnerable group and they need to be protected. It needs to be a necessity for the defense of a right or obligation in law, compliance with international public law. It's been made public by the data subject, or for historical, statistical, or research purposes to extent that the purpose serves a public interest and the processing is necessary for the purpose concerned. Or it appears to be impossible or would involve a disproportionate effort to ask for such consent, and sufficient guarantees are provided to ensure that the processing does not adversely affect the individual privacy of the data subject to a disproportionate extent. Being a country that, and NSEF itself, our universities are very research orientated and driven, and we would want to transfer data internationally as well. And this brings us to international data transfers. And the POPIA provides within section 72 for data to be transferred internationally. And it authorizes it where there is consent from the data subject, the process is necessary for the fulfillment of a law or contract, where there is a written agreement in place upholding the conditions of POPIA in the transfer. Example, a data transfer agreement being signed between parties and institutions. High risk transfers requiring prior authorization from the information regulator. This is transferring special personal information or personal information of a child, for example, to a foreign country without an adequate data protection law in place. So this would be a country that does not have the same or equivalent data protection laws or policies, procedures, even a code of conduct in place. The information regulator, we really truly need this institution to be in place. POPIA provides for the establishment of such regulator, and it is to regulate the privacy and the access of information. The IO is an independent body which is accountable to Parliament. The Information Regulator will also perform functions in terms of the Promotion of Access to Information Act, as well as to take over the South African Human Rights Commission functions as well. The Information Regulator's powers and duties are to educate the public on POPIA, and in turn, with the NSEF Code of Conduct, that will also be part of their duties. Not only will NSEF do that, but also the regulator. And the regulator is to monitor and to enforce compliance. Issue of codes of conduct, which are sector specific, for example, the code of conduct that NSEF is drafting, is to be followed by the responsible parties when processing information. It's to receive and investigate complaints as well. The IO is to mediate in matters. It is to conduct research on policies and regulations, regulate nationally and internationally to advance the protection of personal information. And how is it enforced? Well, an aggrieved data subject may lodge a complaint with the information regulator. The information regulator may investigate a complaint if they are of the opinion that a complaint should be investigated on reasonable grounds, of course. And the information regulator may refer a complaint to another body if the complaint in whole or part falls within the jurisdiction of another body. Now, the NSEF Working Draft Code of Conduct for Research is specific to research. So this has been, Chapter 7 of the POPIA makes provisions for the development of such codes, and it's to provide guidance on the interpretation of POPIA in relation to a particular sector or industry or class of information. So codes of conduct are living laws that can be revised and improved periodically or upon request. So the code of conduct will be approved by the information regulator, and then the code of conduct needs to be updated yearly or whenever is required. And why do we want the code of conduct? It's because it's unclear how the principles of the POPIA will apply in practice to research. And of course, we need to have consistency throughout the interpretation and application of such legislation and the code. POPIA provides certain exceptions from the law for conditions of processing personal information for research. How and where do they apply? A uniform approach to the regulation of personal information for research across governmental departments, academic institutions, research councils, and the private sector is required. And the code will alleviate the need for research sector to apply for prior authorizations. Why ASIF? Why did ASIF take this huge burden on, as has previously been mentioned? And it is the ASIF that is sufficiently representative of research and researchers within South Africa. And this is to also complement the USEF Code of Conduct, which has been actually, it's part of the USEF Code of Conduct actually hasn't gone forward, but it's actually been used as guidelines instead. So the two, these guidelines of USEF and the ASIF Code of Conduct need to speak to each other so that it can be, so that there is no overlap. And also because the USEF regulations and guidelines are broader and not specific to research. So the scope of the draft Code of Conduct, it applies to industry and academia. Academic or scholarly research of all disciplines that uses, collects, and processes and stores personal information as part of the research process. And of course, we've got different definitions of what is research, but broadly speaking, it is the generation, preservation, augmentation, and improvement of knowledge by means of investigations and methods pertinent to the scientific or disciplinary, and which is mindful of the value of knowledge for the betterment of society, including open science. The Code of Conduct in relation to other legislation and regulatory frameworks in relation to POPI, as mentioned previously, we do have the Bill of Rights that we depend on. And, you know, everyone has the right not to be subjected to medical or scientific experiments without their informed consent. And this leads into the National Health Act, as well as the 2015 DOH guidelines on ethics and in research. And it applies to research in a broad sense and not strictly to health research. The consent of individuals involved for research projects that involve human participants, health ethics committees to be registered with NHREC, as well as other research ethics committees that require to be registered. International standards, open science, as previously mentioned, data protection laws in terms of the African Union, the European Union, the GDPR, and so on. POPI compliance does not mean that ethics standards have been met, and meeting ethical standards for research does not mean that POPI compliance has been met. Of course, POPI is a piece of legislation, it's law, but it is married with the ethical standards that our researchers need to be compliant with. Of course, there is a midline between the two, but one doesn't mean that the other is compliant. And what is a lawful basis? Why do we want this? And all processing of personal information must have a legal base, a lawful basis. And only collection of data that is relevant and answers research questions, research protocols, and proposals can be done. It cannot change law. One cannot change its lawful basis during processing. Consent, of course, there are limitations to consent, and consent can be withdrawn at any stage by a data subject. As we go through this, one can see that a lot can go wrong, and that is why the Code of Conduct is so crucial to be in place, and why it's so crucial. Its content is so vital to being the guiding document to the researchers on the ground and other people being involved in the research process. A lawful process also, a lawful basis also is in the form of performance of a duty in law. For example, the Science Councils established through acts of Parliament or the National Health Laboratory Services. It is necessary for the fulfillment of legitimate interests of the responsible party. For a research institution, the legitimate interests would include research. Consent must be specific, free, and informed. No duress, nothing like that can be tolerated. And that's why the code of conduct is vital, so that there is a document in place besides the legislation to guide our researchers to make sure that certain things like informed consent is received in the right way. Further processing allows for the reuse of personal information for a secondary purpose related to original purpose of collection, where safeguards are in place to ensure the information is only used for research and is not published in an identifiable form. Collection from the data subject, except where the personal information is already contained in a public record, where it is for research purposes or where it is reasonably impractical. Consent requirements. When obtaining consent from data subjects, express consent needs to be obtained. Collecting and processing their personal information by the responsible party for the stated purpose. Storing personal information with information provided on the guide, safeguards and security measures in place to protect the personal information and the rights of the data subject. Sharing the personal information with a third party or another responsible party if relevant. Transferring the personal information outside of South Africa if relevant. The future use of personal information for research purposes, and the de-identification of the personal information for use in further data processing activities. The governance of the working draft code of conduct is for research institutions through their information officers, and they will need to report annually to NSEF on compliance with the code and complaints received in relation to the code. So that is any breach in terms of research. NSEF will handle complaints in relation to the code in terms of the complaints handling guidance provided by the information regulator. The code will be a living law subject to regular review by all stakeholders involved. The complaints handling procedure. Complaints first takes the case to the responsible party. The information officer investigates and can refer to or consult with the relevant research ethics committees that approve the study. If aggrieved, the complainant takes the complaint to NSEF, who appoints an independent adjudicator to review the case. NSEF can refer the case to another body better suited to investigate. For example, if it is an ethical breach of the POPIA Act, then it would be referred to the National HREC. If aggrieved, a complainant takes the case to the information regulator as well. So there is a wide variety of avenues for complainants to take their complaints to. Recording POPIA compliance in a data management plan is vital, as these data management plans are being put in place throughout different universities with the different ethical compliance as well. So the data management plan will be vital to having ethics approval as well. And the data management plans will include things like what is the lawful basis for processing, who is the responsible party, the risk assessment, and where there is high risk, a full personal information impact assessment will be done. The consent processes that will be followed. Risk model for research. What are the potential harms of one study and how can a researcher mitigate these? What is the overlap between the law and ethics in that research? What type of personal information is being processed? Is it high risk? And of course, one of the crucial questions is, will the data or the personal information be transferred outside of South Africa? Then necessary steps need to be put in place to be followed. The use of information matching programs, consent and safeguards that will be put in place, level of the identification of personal information. Now, the code of conduct will also assist the practical, will provide guidance on the practical implications for researchers as well as the research ethics committees. But having said that, the mandate of the research ethics committees is what is the perception of what they actually do? What is their mandate? And their mandate, the ethics committee's mandate, is for ethical review, protecting participants, promoting justice, access, autonomy, and empowerment. Its exact scope and nature of legal mandate often debated, of course, in the form of the Constitution, the National Health Act, and POPIA. Information giving and consent process, the mandatory legal reporting requirements, what is the practical reality of the ethics committees, and it is for them to make sure that the research is ethical at the end of the day. And researchers are actually turning to ethics committees for guidance on POPIA compliance. And researchers expect the ethics committees to play some role in providing guidance. And that is why the Code of Conduct will play that role, that vital role of providing the guidance of how to be compliant, what needs to be done. And of course, what happens if there isn't a Code of Conduct in place? And it is utilizing existing regulatory infrastructure that helps. It's basically the Code of Conduct will be codifying what is actually being done on the ground. And that is research, information, and informed consent is sought after. All these concepts are already being done, but it's just being codified within the POPIA Act, of course, but also giving it a practical guideline within the Code of Conduct. And the research ethics committees are common convergence points for a large amount of research. So it makes sense to propose that research ethics committees are a safeguard to POPIA, facilitating limitation of harm to participants. But what are the implications for the researchers and REX members, as well as administrators? Where does the NSEF Working Draft Code of Conduct fit into this whole realm of research? On an institutional level, of course, the institutions need to be POPIA compliant, broadly speaking. And when you bring it down to the RECs need to be POPIA compliant themselves. So not only does the process need to be that the applicants need to be compliant with POPIA, but of course the administrative side of the committees need to be compliant. And on a researcher's level, the research project in terms of POPIA, it needs to be compliant as well. And that is why the Code of Conduct will provide guidance on how to be compliant. Within the draft Code of Conduct, it will provide supporting guiding documents to make life easier for the researchers as well as the ethics committees. The ethics committees reviewing is very time consuming for the different applications, and often it's voluntary done. The ethics members that sit on the ethics committee, it's voluntary, as well as the ethics administrators. They, even though it's voluntary for the ethics members, there's also time constraints, there's pressures on the committee as well as the administrators. So the Code of Conduct will provide guidance in order to, to not add more pressure to them, and they can do what they do best, and it's to process the applications, and this is to speed up the process as well. The guiding documents NSEF will create a resource page on the NSEF website to support compliance in practice with the Working Draft Code. This is in order to save time, to provide uniformity and consistency throughout. This will allow for a guideline for the researchers and the ethics committees. Potential kind of supporting guiding documents, for example, the information sheets, consent forms, data management plans, just a few documents, for example, that will be added to the supporting docs. The POPIA information sheet, the purpose of these are for when obtaining consent for the collection, use and storage of personal information from data subjects, the responsible party must ensure that they provide the data subject with all the relevant information about their rights, why their personal information is being collected, and what will be done with it. It goes over and above the volume of information required in study information sheets, but there is some overlap. This is information by the law that needs to be given to individuals participating in research studies when utilizing their personal information for any purpose where you get the consent to participate. It could either be a separate template that is given to research participants during the information and consent process, or it could be a proposed wording that can be inserted into the overall study information sheet. And the consent form, it speaks to the POP information sheet and the section of study information sheet, and which is required by law. It could be a separate form again. And of course, there's international considerations that need to be considered as well. In terms of the data management plan and the privacy risk assessment, we spoke about the data management plan. There's a rubric for various aspects of data management that researchers and recs can consider, and the POPI prompts this. There's different levels of inherent risk based on the nature of information being processed. And in conclusion, with final comments, at the end of the day, we've got the legislation. It codifies what is happening on the ground, and it's an application and implementation of the POPI that will be assisted by the code. And we need to be practical in applying the POPI Act, and the Code of Conduct will try to achieve that practicality as well. And the code is aiming for the integration and to streamline the POPI and the research processes that need to be followed. It is a collective commitment to the process and acknowledgement of the code's fluidity that is required. And the Code of Conduct, once approved, will assist in the compliance and application of the implementation of POPI. Thank you very much for the opportunity.
Thank you very much, Eleni. This is a very complex issue once again, and thank you for unpacking it so logically, just to understand how does this code actually fit into the current POPI Act, as well as why USAF has done it, and then also what are the implications then for researchers specifically. Before I ask my two questions that will pertain to editors specifically, I see that there has been some comments in the chat box, and I'm just wondering whether Neil, would you like to perhaps hang out your comment there in public?
Hang out my comment, pardon, in public sounds very strange at this time of the Thursday afternoon. Yeah, so my comment is really perhaps more philosophical than anything. I mean, in the field I'm in, there's a huge debate around the validity of granting rights which would normally be attributed to natural persons to juristic persons because of the abuse of power which juristic persons can wield just through their sheer power, right? So I think about, a massive corporation which is criticized in my Journal of Business Ethics, and they don't like it, and they invoke some kind of protection of private or personal information as a mechanism to either take on the journal itself or the authors or the institutions the authors come from and everybody in between, to, I think, silence critique. So I just always have this anxiety in the back of my head. But I think, and I'm not sure if Susan's going to ask these questions regarding, like, what does this mean? What sort of bureaucracies would a journal need to put in place to protect itself from risk? What sort of checks, what sort of, rubrics of evaluation does an editor need to add on to the kind of more scholarly things we're expected to look at, to scrutinize, to protect, to cover ourselves, instead of airing our stuff at this time, to cover our stuff at this time? Thanks, Chair.
Thank you, Neil. I just want to add to Neil's last comment, and that in terms of editors, what is it that editors have to do? I mean, we promote the publishing of the data that sometimes accompanies articles. So what are those checks and balances we have to? What is it that we have to make sure that we comply with, that we do not overstep in publishing this data? Eleni, over to you then now to answer. Thank you.
Sure, that's a great question. I mean, you can be publishing something that's highly confidential. At the end of the day, one of the safety catches that I can actually recommend is journals asking the researchers for the ethics approval, their certificates. That's quite a big one, because then it's gone through the processes. You've got the proof that it is there. And if it is a high risk project that's been done, then you can actually see, okay, well, it's gone through the processes. Do you want to see what mitigation steps were taken in order to protect data subjects, the personal information that's been put in place, those kinds of things? It's a good question, and I haven't actually been posed, because it's always, I'm always on the other side of it. But I would recommend that you ask for that ethics certificate, and that would be a huge, huge safeguard for the journals and for the editors to know it's gone through the ethics approval, and knowing that a data management plan has been put in place, that the necessary safeguards have been put in place to protect the data subjects and that as well.
Thank you. Can I just add on, perhaps, while we're on what the editors as such, then editors do have access to quite a lot of personal information, meaning emails, addresses, institutions, job title descriptions, etc., etc. So what are the risks there?
Okay, you know, you must always have a disclaimer of why are these people contacting you? Are you allowed? You must always ask the questions of, can I use your email address? Can I use your personal information? And be specific as to what is the purpose that you want that consent for. It's always better to take it one step further and request it not verbally, but outrightly to have it, and especially to get that in writing. As editors, it's quite a interesting area, because you're dealing with that information, as you said, the personal information all the time. So if they're contacting you, they are providing you with that personal information by contacting you. But also, having said that, how did they get your contact details? You see, so it just depends in where in the process it is, but always ask for that consent. I mean, why would you have those email addresses, names, dates, you know, all that information? You must always think, what is the purpose? Why do I have it? Do I need to ask permission to use it for X, Y, Z? Okay.
Thank you very much. Leslie, I'm going to hand over to you. You had a question there.
Yeah, thank you. I mean, first of all, you know, thank you for this incredibly clear presentation, and for all the work that you and your colleagues are doing. It's really helping me a lot. One thing that's sort of coming up a lot in health-related research is people, particularly people doing community-based research in sort of rural areas, wanting to recruit participants for their research projects, which may ultimately have benefits for participants. How does one deal with the issue of recruitment into a study? So I go to a health facility in a rural area, and I want to be studying some condition. My assumption is that the health facility may not share the information about the users of that facility with me. Practically speaking, what my colleagues are saying is that if you leave it to the health facility or to the Department of Health to contact people to ask for their information, because of literacy, because of all of these sorts of things, people will not consent to give their it doesn't mean that they're disagreeing, but they won't consent to even be approached for the research. So that's, you know, what happens about recruitment of vulnerable populations into research in the first place? Thank you.
Eleni, Michelle, I'm quite sure Michelle is also burning to add on this particular. Eleni, you can go first, then Michelle, if you'll then hop in after her.
I'll defer to Michelle on this one, and then I'll add on.
Sure, Michelle.
Thanks very much, Leslie, for raising that. You know, I think it is important, and you know, it could even lead to people being paid for making information available. So one has to be very careful. I think it is about being responsible, and also, you know, having the ethics oversight on any research. So I think the ideal would be, and I think Jennifer refers to that, is that, you know, when anybody gives their information, that they should be requested to say whether they would be happy for their details to be passed on for the purposes of research. So I think that would be the recommendation, is to do it right from the beginning. But you do raise an interesting point when you talk about vulnerable populations and whether it's practical in like a rural community to actually do that. But I think, you know, one would have to look at this from an ethics point of view, from a protection of the participant. And so, there may be a process that would be followed. Like if the list were given, then there would have to be a specific way that would be followed to actually approach the individuals. And I'm very much a proponent of community engagement, that, one before you take any research project to field, that you need to actually either talk to community representatives or responsible persons in the community to tell them about the project and make sure that they are on board with, the broad questions, the importance. So I think that is important to do. And then, of course, there's always that thing about, is this research in the public interest? And, is that something that would override? Eleni referred to COVID-19 research. So would it be, acceptable if it was about understanding more about susceptibility to COVID or to severe disease resulting from infection, to then say, a list could be made available, but then the way that you approach the participants has to be very carefully done and responsibly done, and they must have a choice to say no.
Thank you. Thank you. That's very helpful. Thank you.
Eleni, do you want to add?
I think Michelle's covered it. She's correct in saying about the ethics processes and knowing how you will approach your participants. That is all laid out in the ethics application, as well as the data management plan as well. Thanks.
Thank you, Eleni. There's just a last comment then there from Neil that says another very basic issue that I see brewing. Where are we going to find reviewer contact details as institutions increasingly hide these and journals don't publish? So I think that's starting to get part and parcel of the nature of the beast. I'm not sure if there are any comments from you, Michelle, Eleni?
Probably the editors know more, but I'm increasingly seeing, really reputable international journals actually making the reviewers public. If you look at the African Academy of Science, their open platform, you know exactly who's reviewed it, what they've said, and what the responses have been. So I think, every journal will have their own policies and will have great debates about this. But I think there's been some kind of fear that people may be less likely to review if they knew that their names were going to be made public. But it is a way of ensuring responsibility from the reviewer point of view as well.
Thank you, Michelle. And I suppose, Eleni, if one follows your advice, namely to upfront request and state sort of your intention, then I suppose then you can sort of circumvent this whole situation.
100%. Unfortunately, it is the nature of the beast, as has been said, and it's all about consent. If you can get that informed consent at the beginning, it should be fine. And that goes in any kind of context. Informed consent at the end of the day, if someone knows exactly what their personal information is being used for and they give that consent, then you're covered basically. And of course, if you can, in terms of research, if you can de-identify that personal information as well, even better. And the POPIA Act, it's something that we're all learning and grappling with, and it is a learning curve. So all these funny nuances will be coming through, and we'll need to deal with them when and if they come about.
Thank you, Eleni. Can I perhaps ask for some conclusionary remarks from Michelle? Perhaps you first, and then Eleni, and then I would like to close the session.
Thank you very much, Susan. And I just would like to thank the editors too for helping us protect, the way that we publish our research, making sure that it is done in a responsible manner and that we do continue to protect the interests of the participants, whether it be as individuals or in terms of either stigmatizing or adversely, reporting something on a community or a group of people. So I think, very important role for editors to play in that regard, I agree that we often rely on ethics, but we also rely on common sense and on reviewers. And then, of course, the editors also making judgment calls all the time, which is a very tough thing to do, but a very important thing. And as a researcher, I have great respect and appreciation for the enormous amount of work and care that goes into assuring responsible publication of research. So to thank everybody for that.
Thank you, Michelle. Eleni?
Yeah, thank you. And thank you very much for the opportunity. It's been fantastic to explore the other side of this. I mean, I usually am the one that protects our institutions and our researchers. So it was great to be able to be part of such a forum as well. And I mean, at the end of the day, like Michelle says, common sense. We need to be reasonable about applying the POPIA Act specifically and the Code of Conduct. And hopefully the Code of Conduct will provide that practicality that we need on the ground. Thank you.
Thank you very much. So thank you to both of you again for your time and being available to actually present us with this. If we did not achieve anything, at least we did raise awareness for the Code of Conduct for research. And I'm quite sure that participants on this call can go back to their institutions and say, did you know? And that was also part of our sort of objectives of this particular session. I know it's quite a difficult subject to deal with. Colleagues, this then leaves me to draw this session then to a close.
Susan, this is Himla. Sorry, I've been trying to attract your attention.
Sorry, I was about to hand over. Thank you, Himla. Welcome to jump in here. Thank you so much.
Thank you. Thank you, colleagues. Special thank you to Eleni and Michelle for bringing the Code of Conduct for research into perspective. As Susan has said, this has been a journey that NSEF has embarked on since September last year. And I want to take this opportunity of thanking Michelle Ramsey and Rachel Adams, the two co-chairs who have been working together with all the experts within their groups, and also wish to acknowledge them for bringing us where we are currently with a very, very compact and exhaustive draft code, which was put together following quite an exhaustive and transparent process of stakeholder engagement. And I want to emphasize that this has been a stakeholder engagement process, that whatever we've put together through these groups has been done in a consultative way. And as you can imagine, if you have 20 people in the room discussing the POPIA Act and how the Code of Conduct should be drafted, you'd get more than 20 different contributions from participants. So I wish to thank the team for getting us to where we are. And just to say that the reason why the process has been stalled a little bit is that the document is too exhaustive. And after consulting with an expert on Code of Conducts from a legal perspective, we have resolved to engaging such an expert in helping us tailor the document in a way that would be more user-friendly for submission to the information regulator. But coming back to the question that was asked by Leslie, to which Michelle and both Eleni provided insights, having conducted field research myself, and Michelle has alluded to this, the process of community engagement is absolutely vital. And while informed consent is mainly seen as seeing a signature, the big issue is about the informed component. The researcher has the obligation to ensuring that the information that is given to participants or at the community engagement component of the research is well thought through, is easy to communicate, and in a format that can be picked up by the least common denominator. By that I mean it should not be written as we write for our peers, but has to be put together probably with tools, either linguistic content, graphics, etc., that is accessible to the communities among whom you work. So informed consent, with a lot of emphasis on the informed, is absolutely necessary. And Leslie, if you're working in a rural area, say in a community clinic, etc., you could use the infrastructure there to help disseminate information that so-and-so wishes to conduct research, and this is the topic, and to help use them to advertise your presence in an area. And at the end of the day, participation is completely voluntary. And as Eleni has said, the protocols for protection of individuals' information should be part and parcel of your ethics and your on-field protection. So I think a lot of what we are doing with the code of conduct is already very much entrenched in the ethical code of conduct that we subscribe to, but with the emphasis on ensuring that the POPIA Act is brought into context with that added value of protection of individual information. So with that, I just wanted to thank the entire group who have worked on this, together with the ASAF staff who have been supporting both working groups and the stakeholders who have come to the party to join forces with ASAF in ensuring that we do a good job. And at the end of the day, this resource is the advancement of scholarly support that the Academy wishes to bring to the scientific community. So thank you, Susan, for allowing me to have at least a little bit of a soundbite into this component of the discussion. And I hope that we see this, see the back end of this sooner. Thank you so much.
Yes, indeed. Thank you very much, Himla, for those closing words. Much appreciated. Kian, can I hand over to you perhaps just for final comments and then the closure of the 2 days webinar? Thank you.
Sure, just a few comments. I think it's been a very intensive 2 days and people must be very tired. We've also had to deal with load shedding and all the consequences that brings. So it's been, I think, very pleasant for us to see a good turnout for most of the time and people participating as they have. My thanks to Himla for the wonderful summing up of the last session. Really very clear and reassuring, in fact, given the complexities of what we're going to have to be dealing with as we negotiate all these new regulatory systems. What I will do, rather than keep everybody on board for another 15 minutes, is to ask the SPU to circulate some comments that I am putting together early next week, in which I've tried to draw out some of the key points from the 2 days, although this morning I was cut out because of power outage. And I think that what we also need to try to do is to remain in contact with delegates more regularly than just once a year or once every 2 years, depending on the state of pandemics and so on, with just short notices saying that we're still here and we look forward to your comments. I see Mapoti has just entered something into the chat about asking for comments, your assessments of the 2 days. A single sentence will do, help us to keep us on our toes and to respond to points that may get lost somewhere in the minutes writing or which didn't come up, but which you think are actually important arising out of the event. And just to reiterate the point that I made yesterday, was that I think this particular kind of meeting of editors may well be unique in the world. We're very lucky to have a well-staffed and well-funded academy to manage these kinds of discussions at a national level. And it's now up to all of us as individual delegates to communicate what we have learned at our own universities and our own schools and our own faculty boards and senates. I think a lot of information that is available through ASAF doesn't really get down to the grassroots levels of departments schools, faculties, and even senates. Although it is available on the website, I think we need to popularize this information and to bring the importance of what the Academy does to every single academic at every single university. And my final thanks then go to the to the publication unit for pulling this all together. And I know that you might take tonight off, but you'll be back on the job first thing tomorrow morning. And I really have to thank everybody at NSEF for really pulling out the stops on everything that they do all the time. I've learned over the last 6 months about the pressures under which you're working, and you're working for us, for the community of scholars. And so thank you for that. And thank you for organizing this meeting. It went off without a hitch for the most part. And thanks to NSEF for facilitating it. So that's me. Does anybody, Susan, do I hand back to you? I don't know what the protocol is.
I think it's good. Thank you very much, Kian, and thank you very much for that words as well. Yes, and all we can say, it's our pleasure. We enjoy what we do, and I do hope that participants to this webinar has got a flavor of how scholarly publishing would look like in going forward. I think there are many things changing and happening, and that we are now at the next level of sort of developments in the scholarly publishing arena. Again, thank you to my staff. We cannot do this without them. And also for all the visuals, etc., most appreciated. And thank you, colleagues and the participants for hanging in there amidst all this load shedding. It has been amazing 2 days. Thank you very much. Thank you. We can conclude now.
Bye, everybody.
Okay, bye.